Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about sentencing. Cases that should have gone to the Supreme Court of Canada, but didn't. Johnny Owasis was convicted of some sexual offenses, and as a result of his convictions, the Crown sought a dangerous offender designation. This would subject Mr. Owasis to an indeterminate sentence, meaning that he would only be released from custody once he was determined no longer to be a danger to the public. His sentence could be for the rest of his life, and in many dangerous offender situations, it often is. Mr. Owasis argued that the dangerous offender protocol was inconsistent with the rest of the sentencing objectives in Canadian law because it didn't deal with Indigenous issues in the same way that Canadian sentencing cases do. If an offender who is of Indigenous heritage is being sentenced by the court is obligated to consider what is known as Gladu Factors. These are factors that affect the individual who is involved in the case, who is being sentenced on the basis of their Indigenous heritage. Factors that stem from the effects of colonization, multi-generational trauma, residential schools, alcoholism, mental health issues, poverty, all of the different issues that disproportionately affect Indigenous people in Canada have to be considered by the court and taken into account in a sentencing process. However, in a dangerous offender hearing, there is no statutory process for the Gladu factors to be considered, and they aren't given the same weight or consideration typically as they are in a regular sentencing proceeding. Mr. Owasis argued that this was unfair, that it essentially created two tiers of sentencing for Indigenous offenders ordinarily, and separate sentencing for an Indigenous offender who is subject to the dangerous offender provisions. He argued that this rendered the sentencing in his case unfair. And obviously this is an important issue. As we see more and more cases involving people who are raising issues that have arisen out of colonization, and as we as a society develop a more nuanced understanding of the way that colonization and its impacts have affected people who are of Indigenous heritage, is it not reasonable that that should be applied to the dangerous offender process? And should we not have clear guidance from the Supreme Court of Canada about where in the dangerous offender process this Gladu principles fit? This is an important issue that affects all Indigenous people in Canada because Indigenous people are more likely to receive longer sentences, to receive harsher punishments, and more likely to be the subject of a dangerous offender application. So should the courts not be required to consider that in making the order? This was an important opportunity for the Supreme Court of Canada to further the work that is being done in this country to correct the racial injustice, and unfortunately they missed that opportunity here. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.